Welcome back to Time Served, the channel that scans the docket so you don't have to when you have a rap sheet as long as the River Nile while it follows you. And boy, oh boy, does this follow Mr. Casanova, as I believe his name has nothing to do with his demeanor, as it seems he is an old angry man. And Judge, make sure he does not get off, because this time this wasn't as bad as his priors. Let us know how you feel about this man by commenting below. Like and subscribe, set your notifications to all. Let's roll, nerds.
All right, so on this case, let me see. The jury found him guilty, and he's coming to the court for punishment.
Yes, sir. Life for probation.
All right, thank you. All right, court is calling 2024 CR 007360-2, State versus Richard Casanova. Can I have parties announced for the record for the state? Defense.
Michael Collins, attorney for defendant, present ready, Your Honor.
And are you Mr. Casanova?
Sir.
All right, he was found guilty on December 4th.
Yes, sir.
By the jury, and he elected to have the court assess punishment. The PSI was waived by defense and the state. Is that correct?
Yes, sir. I did.
Any defense waive PSI, we have no objection to moving forward.
Okay. And so we set it for this time for anyone to present any evidence or if they had any witnesses.
We have no witnesses other than my client, Your
The state criminal witnesses, Judge, we are going to admit impact into evidence.
Moving to amendments 67 1 and 2 for the sentencing.
No objection.
We are also going to ask the court to consider all the evidence that was admitted in the defense.
All right, states exhibits 1 and 2 are admitted without objection and they appear to be judgments. Any other evidence, state?
No.
All right, defense, any evidence?
Just argument, Your Honor.
All right, did you want to call your witness or no?
Let me ask him if he wants to speak, Your Honor.
Okay, sure.
Do you want to touch it?
Yes, yes.
Yes, Your Honor. I would call my client.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Richard Thomas Casanova.
All right, do you want to ask questions or is there something
I think he wants-
specifically he wished to say?
Richard, do you want to address the court at this point? About the punishment phase?
I just want to say that when I get out, I'm not going to go back to my mom's house or my daughter's, and I'll go to Hayden for home. And I wasn't aware that I couldn't go, to try to get my mail. I thought that the protective order had expired because it was 1 year, and I could never get my mail, so I didn't know what was going on. I was put on the street pretty much. I didn't have no place to go. So.
All right. Any questions?
No question.
All right. So what I can tell you, Mr. Casanova, the fact that you're telling me that you didn't know about the protective order, that is what's considered as mitigation evidence. These type of offenses are sort of like strict liability. Was there a protective order in place? That's either yes or no. And did you violate it? Yes or no. So that's the way these type of charges are. There are some charges that are slightly different, but not this. Okay?
Yes.
All right. State, what are you requesting for punishment?
Given the history, Judge, and practice of the first violation of protective order, we ask for here's to the scene.
All right. And defense, what are you requesting?
He'll be requesting probation in light of he's been incarcerated since the date of the offense, which was late April of 2024, Your Honor, hasn't been in trouble with jail. And he is expressing to the court that he has no intention of going back there, Your Honor. He was under what he thought was a mistaken belief of the fact, Your Honor.
I do have one thing to add. He was indicted as a repeater. We're just going to ask for the judge might touch on that.
All right. So let me see the indictment. And you're proceeding on the repeater enhancement allegation?
Yes.
All right. Mr. Casanova, you're still under oath. I'm going to read the repeat offender enhancement allegation paragraph, and I need to know from you if it's true or not true. And before you answer, you can discuss that with your attorney. It states, and it is further presented in and to said court that before the commission of the offense alleged above on the 24th day of June 80, 2010, and cause number 2007 CR 2886 in Bexar County, Texas, the defendant was convicted of the felony of criminally negligent homicide with deadly weapon. So the question is, how do you plead to that, true or not true? And you can speak with your attorney before answering.
True.
Right. Then the court will find that true based upon your plea of true and based upon state's exhibit number 1. Now, what the court's understanding is that this location he went to, is that the daughter's house, mom's house, his house? It appears that during the testimony, he was saying that's his actual place of residence. I know sometimes when there are violations of protective orders that are filed, whoever they deem to be the offending party, they make them leave, whether their name is on the property or not. So the persons who were at the home, what I remember from the testimony is it was his daughter. Is that correct?
Correct, Your Honor.
Yes, Judge.
So is this protective order involving the daughter, that location, and his mom?
Daughter. I would have to check to see if there's any other parties that are protected, but I believe it's.
That's the only one that was unprotected.
Okay. So here's my question.
Daughter and the resident and that address.
Yeah.
So here's my question. Has anyone spoken to the daughter?
So I can inform the court of what the daughter told me, but of course I don't know how.
Well, do you want to speak to the attorney before? Yes.
You want give me 30 seconds.
Sure.
On the record, so I did speak with the complainant one time after one of our investigators went over to the address to make sure that somebody was present. We have called her multiple times, texted her. She had not returned her calls until one of our investigators went to the location and found her. She called me. I spoke with her. I did explain to her about the case, about being in trial, and her coming over to present her testimony, and she did indicate to me that she did want to testify. However, she could not make any arrangements because she is the caregiver of her grandparents, and she could not make coming to court for that. We did make efforts to reach out to her over the phone. We confirmed that was the correct number that we had, and after the guilt innocence, we did try to inform her about her coming over to testify during the sentencing, but she has not returned our calls. I have not sent out an investigator to her location again.
All right. So part of the consideration the court takes into consideration, or evidence that the court takes in consideration, especially in this case, one, of course, is protecting the community, and two, protecting the parties of the protective order. Now, sometimes family relationships between fathers and daughters, fathers and sons, mothers between their children as well, it's difficult. So what I would like to know, if it's possible, if it's not possible, I'll make my ruling without this information. But if you all want to just try again today, state you and the defense counsel to reach out to the complainant, find out if she has any fear of him, and, what her thoughts are on sentencing. And then I'll make my ruling. But I'll make my ruling today.
As long as I can be present on the conversation.
Yes.
If we aren't able to get a hold of her today, I just want to make sure with defense, if you have any objections, we can bring it on Zoom.
No?
Okay. All right, let's try to do that. I want to make the right decision on punishment, okay?
One caveat, I'd like to be able to handle it sometime today because I start vacation tomorrow.
No, we're starting it today. So it's going to happen today. If she appears, she appears. If she doesn't appear, she doesn't appear.
Can we have 5-10 minutes?
Sure. This is just information I would like to have.
Sorry.
All right, thank you.
15 minutes later.
All right, we're back on the record with Mr. Casanova. This one moment.
Have a seat. I can take over it.
Let me just grab your file.
Oh, okay.
Here we are. All right, we're back on the record and 2024 CR 007-360-02 State versus Richard Casanova. All right, State, did you have a chance to reach the complainant?
We have, Judge. We have not successfully reached the complainant. Our advocate did come down earlier, and while defense was present, she did make 2 phone calls to the number that we have for the complainant. There was no answer. She did leave a voicemail informing the complainant to call us back for the next 5-10 minutes as the court asked questions. We did offer appearing over Zoom as an option in the voicemail. She also sent a text message, but that was more than 10 minutes ago. So we have not been able to reach it.
All right. So and are both parties still wishing to proceed without the input from the complainant, State?
At this point, Judge, it's pretty clear that the complainant does not have any part of the session.
All right, defense?
We proceed without.
All right. So what I can tell you, Mr. Casanova, I don't think that probation will be appropriate in this case. I have to consider your entire history. It's not just this one incident. All right. So then the question becomes, the state is requesting 8 years. What are you requesting?
I request a minimum, Your Honor, 2.
Okay. All right. This is what the court is doing. The court is finding the enhancement true based upon your plea of true and based upon state's exhibits 1 and attachments. The court has heard all the evidence in this case. Based upon the evidence that the court heard, I understand the nature of protective orders, but it doesn't appear that from the testimony that the court heard that the defendant was there to be violent, that the defendant was there to cause a disruption. The only testimony that the court heard was that he was there to collect his mail. And the testimony that he gave sounded believable to the court and sounded credible, because otherwise, why would he just be waiting, if not to pick up his mail, as he said? But we're not allowed to be at the residence. You understand? All right. The court is going to sentence you to 3 years in the prison, give you credit for any time served. Let's see. All right. I don't have your trial court certification in here. You may have filled it out,
Oh, I did.
but it is not here. So do you mind filling out another one? For
Yes,
the
sure.
court? And then I'm also, as a part of your sentencing, I'm going to order no contact with let me see. I don't have the state's exhibits here. Who is the
Crystal with a C, Casanova.
There's to be no contact with Crystal Casanova. Do you understand?
Yes, Your Honor.
That's from here till eternity. Now, if she decides that she wants to see you, then you all will need to file motions with the court and ask that that be removed. Do you understand?
Yes, Your Honor.
So any location where she may be, you're not allowed to go there. Do you understand?
Yes, I do.
Whether it's your house or not your house. If it is your house and you feel as though you have a right to be there, that's something that needs to be settled in the court of law. That's not something where you just show up.
Yes.
You can't show up for your mail. You'll need to go to the post office and ask them to change your mailing address. Do you understand?
Yes, Your Honor.
All right.
Sure. Sign. This says you have a right to appeal if you'd like. Yeah,
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I understand.
All right.
That's-
This is a jury trial, so you do have a right to appeal. We can go off the record. If you wish to appeal, your attorney will know to file the notice. And if you cannot afford appellate counsel, one will be appointed to represent you.
Okay.
All right. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Counsel,
Okay.
you're welcome.
That excuse, Your Honor?
Yes, you may be excused.